my name is Eileen Mostricht, and today I wanted to talk about the difference between joint tenancy with right of survivorship and tenancy in common. These phrases are usually used to describe ownership in real estate, but they certainly can be used to talk about ownership in other assets as well. But for just ease of conversation, we're just going to be talking about real estate. So joint tenants with right of survivorship means that if you two people own property that way, then when one of them passes away, the other one will own the property 100%, no probate, nothing else has to happen. That other owner just now owns the property. If, in contrast with tenancy in common, the two people will each own a divided share of the property, and if one of them passes away, then the other one just owns their 50%. And then the 50% of the person who deceased will have to go according to their own will, or if they had a trust, it would go according to their trust if they had placed this share in their trust, or if they didn't have a will or a trust, it would go according to the intestate laws of Florida, which are the laws that apply if you don't have a will. So this can be an important distinction in how you own property, and a lot of people kind of confuse the terms. For married couples, they own the property as tenancy by the entireties. That is sort of an elevated joint tenancy with right of survivorship. And so if one spouse dies, the other spouse will own the property 100%. Importantly, you have to state in the deed what you want. If you don't, then the default is going to be tenancy in common, which is those divided shares. If you want joint tenants with right of survivorship, you have to state that in the deed. So if you buy a piece of investment property, for example, with your sister, you would have, and you want it to be owned as joint tenants with right of survivorship, then you have to put your name, your sister's name as joint tenants with right of survivorship. If you just put your name and your sister's name, then the default is going to be tenancy in common, meaning you're each going to own a 50% divided share. If one of you dies, there's not going to be an automatic ownership by the other one. I mean, sometimes you might want tenancy in common. You just have to understand the difference and that there is an important distinction here. For married couples, as long as the deed states husband and wife, then it will automatically be tenancy by the entireties for them. They don't have to say tenancy by the entireties. They can if they want, but it doesn't have to say that. But it does have to say husband and wife. So these are important distinctions. So if you are buying a house or buying a piece of investment property or joining up with various people to own real estate, make sure that you understand how you want to own it, and that whomever is drafting the deed, be careful to read the deed. Whomever is drafting the deed actually puts what you want. It can be very important if one of the owners passes away.